All right, good morning. Today I'm going to continue with the political spectrum. And I think today's, if you want to call it political spectrum number 4, I think that today's may be the most eye-opening to you and may explain more than anything else. You know, a lot of students say it's so contentious, there's always arguing all the time. It's so, they're so loud, they can't get along. I'm going to try to explain why today. This is really what you're going to see as we go towards the election this November. This is going to be a major issue, one of the major issues, okay? So this is about the 14th Amendment, all right? Here we go. The 14th Amendment, so I sent you this piece of paper, all right? And this is the 14th Amendment is a little bit longer than this, but this is the particular piece of paper that I sent you. If you can run it off, that's terrific. If not, just take a piece of paper and you can see I've got it landscape style. Just write 14th Amendment right here. And what I'm basically going to try to do is I'm going to try to do this this is going to end up being in thirds. That's how it's going to work. All right? So when it's all said and done, mine sort of looks like this. How's that sound? All right? So you have, and then there's going to be stuff down each side. So I'm going to try to keep it in thirds. Does that sort of make sense what I'm trying to do with this? All right, so here we go. The 14th Amendment. Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, or deny to any person within its jurisdiction the equal protection of the laws. All right, now, again, many students say this is exactly what I'm talking about, Mr. O'Brien. Good Lord, what the heck does all that mean? All right, here's what I would first of all say. Take a look at the date this thing was ratified, 1868. What has just ended 3 years previous? The bloody Civil War, the bloody United States Civil War. Brother against brother, northern states versus southern states, Union versus Confederates. And this is still very fresh on everyone's mind. All right, so now one of the things, of course, you know is that, well, the Civil War freed the slaves. And this is what the 14th Amendment was all about. All right, so now let's write a couple things down here just to make sure we know a lot about the 14th Amendment. First of all, it was written by a Republican from Ohio. All right. And the issue that they really wanted to deal with this amendment was, all right, what do we do with all these freed slaves from the Confederate, the southern state? What are we going to do with them all? What happens to them? Okay? Now, you need to understand something. Maybe you don't know this about the Civil War. There was certainly slavery in the United States. However, the United States had ceased, they had stopped being part of the slave trade. And they stopped being part of the slave trade way back in the earlier 1800s. So, what does that mean? That means that yes, there's slavery, but there's in the United States, but there's not still African slaves coming over. That didn't stop, but that had stopped as far as the United States was concerned. There was no new slaves coming from Africa still at the time of the Civil War. The slaves in the southern states were people who had been there, whose really their ancestors had been there for generations by this time. And basically, the argument became, okay, what are we going to do with the slave? This amendment is going to make all the blacks, former slaves, we're going to make them citizens. And the argument basically, we're going to give them equal protection under the law. We're going to make sure that they have the same rights. Because they are now citizens, we're going to make them have the same rights under U.S. law. And the key point, and the point I'm trying to make here, is that technically the argument, the way they sort of got around this, the way they sort of justified this was all of these former slaves of the Confederate States, where had they been born? They had been born in the United States. Yes, the southern states had seceded. Yes, technically the southern states claimed they were a different nation for a particular period of time from 1861 to 1865. But because the Union, the northern states were victorious, they looked at it upon, well, we've never stopped being the United States, even though southern states were still the United States. So where were these people, where were these slaves all born? They weren't born in Africa and still brought over. The slave trades, where were they born? They were born in the USA. And that is the gist and why the 14th Amendment was set up in the first place. Okay, so now, let's talk about the two sides here that we want to get into. Okay, so just as I go through this, you just sort of bear with me, and you gotta ride along. All right. And again, like I always say, if you want to stop the tape to get something down, you just go right ahead. Okay, so here we go. Let's go over here on the right side of the 14th Amendment setup. All right. Down the right side. Okay, so this is going to be the conservative side. Obviously, the liberals will be on the other side. Okay, so now here is what I'm getting at, and here's what the big contentious issue is about the U.S. Constitution. How do you view the U.S. Constitution? All right. Conservatives believe that you should view the Constitution based on, this is the term you need to remember, original intent. All right, now what does this mean? This means that amendments are often written to address one particular issue at one particular time in American history. Okay, there's a little bit of explanation here. All right, so there are 27 amendments, and you all know that the first 10 are called the Bill of Rights. The Bill of Rights were part of the Constitution at the very beginning of the Constitution. When the Constitution was ratified in the 1790s, the first 10 amendments were also ratified at that particular time. And the first 10 amendments are very general. They apply to everyone, and they were could be applicable all the way through history. Subsequent amendments, like the 14th Amendment, should be considered, conservatives believe, viewed on original intent. Why was this amendment needed at this particular time in American history? Well, there was a particular issue at this particular time in American history, and it needed to be dealt with. So that's what you do. You write an amendment for it. Okay? All right, here we go. The left side, liberals believe, and here's the term you need to remember for them, liberals believe that the U.S. Constitution should be viewed as something called a living document. Living document. Now, what does that mean? Well, again, I sort of think of clay on the ceramics table. What do you do with it? You can mold it. You can mold it as you see fit. If you don't like how it's molded, you can change the mold and do something with it to make it as you like it. So what does this basically say? And look, lawyers do this all the time. They interpret law. They find other laws to interpret new situations. Liberals are all over this. They love this. What do? You interpret other laws, like the 14th Amendment, to situations as they arise. Okay, so now let's do some examples together. Now I'm going to start writing. I'm going to do some writing here. For example. Okay? For example. All right, so what I want to do here is I want to sort of highlight, I'm just going to underline a particular part of this. The very first thing I want you to notice here is all persons born in the United States are citizens of the United States. All right? Now, that, ladies and gentlemen, is called what we all call, they call this the citizenship clause. Citizenship clause. All right? That's what this is called. That's what this is known as. A clause is a short, shall we say, phrase or sentence. Okay? Now, what do liberals use this for? Liberals say that we should use the 14th Amendment, and what this should basically do is this should allow, and I'm going to give, by the way, I'm going to give both sides, and I'm going to give two examples, and I'm going to give both sides of both examples. Should allow anyone at any time born in the U.S. to be a U.S. citizen. And you can see here what I'm talking about. This is sometimes known as This is known as, there's a term for this, birthright citizenship. Okay? Birthright citizenship. That's what this is called. That's what this is known as. Who uses this? Well, this is used especially by advocates for of illegal immigrants and immigrants in general. In other words, these quote-unquote illegal immigrants, and in many cases liberals don't even like to use that term. The term is used because there are laws in the United States that sort of talk about being an immigrant, how to get in the United States, and sometimes people come in, shall we say, other ways, so therefore they're deemed illegal. People that are advocating for them, in many cases, would say, well, if some of these people are born in the United States, what does this mean? Okay, it says if you're born in the United States, you should be a citizen. Okay? All right, now, the opposite side of this, the opposite argument of this is basically, as you might imagine, use of the citizenship clause in this way encourages illegal immigration, okay, and shall I say immigration, especially through something called anchor babies. Maybe you've heard this term. And maybe you haven't heard this, something called anchor baby tourism. Okay? Now, what is this? What am I getting at here? Okay, so what do some women and families do? They try to cross the border, especially the southern border, to get into the United States, and the woman is pregnant. And what is she trying to do? She's trying to get into the United States so she can give birth to her child in the United States, with the thought process that that baby, since that baby is a citizen of the United States, what will that allow that family to do? They will have an anchor within the United States that will allow them to stay. The new baby is the anchor. In California especially, and this is really, a lot of this is done to a Chinese market, is there's companies that are marketing, bringing Chinese couples over and setting them up in hotels and setting them up with doctors and setting them up with hospital appointments, so these young couples can have their child. The woman's pregnant, they can have their child in the United States. Really, no other country allows birthright citizenship. Now, Canada does to a degree, but the United States is the only one citizenship. But the United States is the only one that does it on a massive scale. And the argument, of course, that would be made is, I mean, how often do you hear about an American couple? Okay, an American couple goes on vacation in Europe, and the woman is pregnant, and then she's in Switzerland, and the baby's coming early. Okay, so what does she do? She has the baby in Switzerland. She doesn't come home and say, "Oh, look at my baby, she's Swiss." Okay, Switzerland doesn't do that, but the United States does do that. Okay, all right. So that is obviously one of the big arguments between the two sides. All right. So now I'm going to give you another example. Okay. So we're going to draw a line here. I'm going to go probably past the bottom of this, and then we will get to. You can sort of see how this is an example of why this is contentious. Okay. All right, so let me sort of underline one other thing here, and we get a different color. Okay, so that's the first clause. The second clause I want to show is, all right, citizens of the United States not deprive, let's see, not deprive any person of life, liberty, or property without due process of law, nor to deny any person within its jurisdiction the equal protection of the laws. Okay, so this is the one that is a big one that liberals and conservatives are very big on. And what we do is we call this one, ladies and gentlemen, we call this one the equal protection clause. All right, that's what this one is known. All right. Now, can you guess who, what modern day group, advocacy group, what modern day issue the equal protection clause is being used for? Well, it is used by gay rights advocates. All right, gay rights advocates. Now, what do I mean by this? And I'm going to say as they argue for gay marriage. All right. Now, what is the argument? Well, the argument is that same-sex couples should enjoy, and that's a word I mean, I'm going to put that in parentheses, enjoy, all right, the right of marriage and its benefits as written into U.S. law. Why should they be allowed to have this? Because what does the 14th Amendment say? The 14th Amendment says everybody should have equal protection under the law. So the gay marriage advocates argue that laws made to benefit married couples, a lot of this has to do with taxes, all of these should be applicable to same-sex couples if they so choose to get married. The Equal Protection Clause. Okay? Now on the conservative side of this, over here, all right, the argument is pretty simple. Okay? The argument is pretty simple. And it's not necessarily an argument against gay marriage, it's an argument for original intent. And basically, they would argue if gay rights advocates want gay marriage, all right, there is a process of getting it into U.S. law. And what is that process? ... The process is get a new amendment. Let's do that. Get a new amendment. There's a process to do this to the U.S. Constitution. All right? Not doing this is what conservatives call government overreach. Overreach. In other words, they are going above and beyond. The courts would be going above and beyond the other branches of the federal government. Okay? there's a process to do things. The Constitution spells it out very simply, how to get a new amendment. All right? And again, I sort of throw this out at you. A conservative would say, do you ever notice how there's not very many discussions in society about getting a new amendment? This is why. Because you people over here on the liberal side who want to use the living document argument, you guys all twist these things all over the place to get what you want today because you're impatient. Yeah, getting an amendment to the United States Constitution is difficult and it takes time. But that's sort of the argument, that it should be done through the process spelled out by the United States Constitution and not just letting the courts do it. Certainly, the argument a conservative would make would be, do you think these guys back in 1868 would have voted for this if they would have known that their vote for this would have been applied to things like gay rights and illegal immigration? Probably not. And so therefore a conservative would argue that that's why the process exists. It's not an argument against gay marriage or gay rights or anything like that. It's an argument about how fast does government work, and you liberals are always in too big of a hurry to try to do things. You liberals have no patience for the timing, the way that the Constitution is set up. And look, you would have to argue that in many instances in which gay marriage was on ballots, in much of the late 1990s, 2000s, and even into the early 2010s, wherever gay marriage was on the ballot, it lost, including very liberal states like California, Massachusetts, and even in Hawaii, it lost. But what do the courts do? The courts overrule the voting of the citizenry. And I would just sort of throw this out at you, is that gay marriage, the gay marriage argument, it was trending in favor. Even though in many cases it had been voted against, generally gay marriage has been trending favorably in the last 20 years. And therefore getting a new amendment to the United States Constitution may not have been as difficult, that difficult. Now, will there ever be an amendment about gay marriage in the United States Constitution? The answer is no, because guess what the Supreme Court has ruled? The Supreme Court has ruled in favor of the gay marriage advocates and gay rights advocates because of the Equal Protection Clause. So the Supreme Court jumped in on this. Okay, now do you see where I'm going with this whole thing? Why this is so contentious? Why this is such a big deal? Why elections are such huge things? Okay, so let me go through and tell the story of the U.S. Supreme Court. Okay, this is the U.S. Supreme Court in 2016. All right, now there's 9 justices. All right, there's 9 justices on the Supreme Court. You see, I have 8 names here. All right, so these are the 4 liberal judges. These are the 4 liberal judges in 2016. They're the same ones today. The 3 women on the Supreme Court are on this side: Ginsburg, Kagan, and Sotomayor. Breyer is also very liberal. These are in 2016 now. These were the 4 conservative judges: Scalia, Roberts, Thomas, and Alito. Thomas is the only African American on the Supreme Court. Roberts is the Chief Justice, so he sort of runs everything. The 9th name was a guy named Kennedy. Okay, Justice Kennedy. And the reason I'm writing it in the center is that very often Kennedy, who was appointed by... All right, so let's go back here just for a moment. All these people are nominated by a president. Obviously, all of these 4 have been nominated by Democrat presidents. These 4 had been nominated by Republican presidents, as had Kennedy. But Kennedy had a tendency to not necessarily vote on the conservative side. He would sometimes, but sometimes Kennedy would jump over to the liberal side. So all of the Supreme Court cases for many years, for really the last sort of, shall I say, 15 years, were always 5-4 decisions. Kennedy, as a matter of fact, as far as the gay marriage discussion that I just mentioned a moment ago, Kennedy was actually the one, even though he was appointed by a Republican president, Kennedy jumped over to this side, and gay marriage, for all intents and purposes, was made the law of the land by a 5-4 decision. Okay, so now what is the point of my story? The point of my story is what happened in, all right, what happened in 2016? Well, the key thing that happened is that Scalia died. Okay, he passes away. He passes away. Okay, so who's the president? Obama. But it is an election year. So the Republicans in Congress basically said Obama nominated a guy. He was a liberal, but he was more of a moderate liberal. So Obama nominates a guy to replace this person, but since it's 2016 and an election year, the Republicans in Congress said, let's wait for the election to happen and let's decide. Okay, well, Trump scores the big upset. Trump wins. And so one of the very first things he does is he gets to appoint a new justice. And that guy, his name is Gorsuch. And I believe this is how it's spelled. Gorsuch. Gorsuch, as a matter of fact, a guy from University of Colorado, where I went to school. But Gorsuch was certainly a conservative. Okay, so this is now we're getting into 2017, 2018, so everything's fine. All right, well, the big thing that occurs is that Kennedy retires. Okay, now here's the big issue. Here's the big angst of this whole thing. When Kennedy retires in, I believe it was late 2018, what does the Republican President Trump do? He nominates another conservative judge, and that man's name was Brett Kavanaugh. All right, and now you see the problem that liberals believe they are facing, and that is, what are we going to have here? We are going to have a constant 5-4, even if, for example, Trump loses in 2020, the Senate flips over to the Democrats. The Democrats maintain the House of Representatives. So the president, the executive branch, and the legislative branch are both held by the Democrats. But what do you have in the Supreme Court? What do you have in the Supreme Court? You have a conservative majority. Now there is some debate. Is Roberts moving to the center? Is Roberts going to be this, what they call a swing vote guy? So there's some question about that. But the real issue is right here. This is the real issue, is Ginsburg. She's the oldest, she's now the oldest person on the Supreme Court, and she has had a lot of health problems. And she basically is saying she is refusing to retire. She's going to try to outlive the Trump presidency. Now the fear is, on the liberal side, is that Trump wins again in 2020, and because of her age and because of her health, and again, God forbid she dies, but she needs to resign or is incapable of moving on, then what is Trump going to be free to do in his second term? He's going to be free to nominate now what would be a sixth conservative judge. And even if Roberts does move to the center, they would still have 5 conservative judges against 3. And by the way, I believe the second oldest one on the Supreme Court is Breyer. Thomas is the third oldest one. All right? These 3 guys, really, Roberts, Alito, Gorsuch, and Kavanaugh, they're all young guys. They're going to be around for a long time. Kagan, Sotomayor, they'll be around for a long time. But here's the one thing that the liberals see as the big problem. Now, what did they do? The liberals, the Democrat Party tried to nail this guy. The Kavanaugh hearings were very contentious, and this is why. They tried to knock this guy out by bringing up things that allegedly happened that he did in high school. Okay, so that's why they went after him so hard, because of all this. The Democrats have threatened also, if they win the presidency and the legislative branch, they have threatened to what is called pack the Supreme Court. This is Roosevelt, Franklin Roosevelt, one of the most liberal presidents we've ever had, did this in the 1930s. You can see, even if the Democrat president wins, it's still really a 5-4 thing. So what do you do? Well, you pack the Supreme Court. You don't have 9 justices anymore. You have 11. So what would we do? What would the Democrats do if they take the White House and the legislative branch? Well, you add 2 more names down here, and now what have you got? You've got a 6-5 every single time. That's not really legal. That's not really how it's written into it. But the point is, what are we talking about? We're talking about how liberals believe in a living document. All right, so this is sort of what I'm getting at here. This is what I'm getting at with you all. What do you sort of think based on these things? Is it original intent or is it living document? And I've given you 2 very specific examples of this, but my real point is now you can see, if you ever wonder why is it so contentious, why is everybody so, it really has to do with the Supreme Court. It has to do with who, because yeah, you can vote out a president after 4 years. You can vote out these guys in the legislature after 2 or 6 years. These people are in for life, and that's the argument. This is why this is so. This to me is why this is all so contentious. Okay, everybody, there you go. That I hope explains a whole lot to you. The 14th Amendment is very fascinating. I hope that you got something out of this conversation. And I hope this makes sense, what I'm talking about. Hope it makes you think. All right, everybody. See you next time. Aloha.